Alex here with part 147 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the Supreme Court appeal that I filed a few videos back. I am leading off in that case with a motion seeking leave of the court to file an opening brief. This is something that I ended up stumbling over, I think 1 or 2 appeals ago, where I filed an opening brief without asking permission. And at the time, the rules of appellate procedure required you to ask for permission before filing this if you were not an attorney. If you were an attorney, you were just plain required to file an opening brief. This rule has changed since. I know it has. Maybe 3 or 4 years ago it changed. And now you don't have to ask permission. You can just file whichever one you want. You can file an opening brief, or you can file, what do they call it? The proper person informal brief. I think that's the other one. And you don't have to ask permission. You can just go ahead and choose whichever one you want. So I think my mindset at this point in time was mostly positive. I felt that this was an appeal I was going to win. In fact, I don't even really think I put much, I don't want to say effort. I put a lot of effort into it, but I don't think I put much, I guess, words into it. It's not a wordy brief. I think if I remember correctly, it's like a 3 or 4 pager. I might be wrong. It may be later on the line that I file a 3-page opening brief. I do that at some point, and I do win that appeal. But I do sense that with this particular situation, it's not going to be a very complicated issue. There was a law, and the court did not follow it. Still, it's hard to say until I actually get to the document. So this is me asking, or actually at this point in time, we should go ahead and take a look at this particular motion that I have filed. Here we have my motion seeking leave of the court to file an opening brief. First, standard introductory paragraph indicates I am the appellant and that I am representing myself by stating I am appearing in proper person. That's what I'm indicating to this court. And I am indicating that I'm filing this motion seeking leave of the court to file that brief. It's going to be pretty short, I imagine. Points and authorities, and here I am citing Rule 46 subsection B of the Rules of Appellate Procedure. And I am indicating that I have demonstrated an ability to draft briefs in the past, and that I've used those briefs to better articulate my position and cogently argue in support of my cases. And then I go through a list of cases that I have won, including Falcone v. Secretary of... No, wait. This is Falcone v. Corres and Real Estate. Here is Falcone v. Secretary of State. Okay, so that's the one that we went over in this series. And that I am concurrently providing the appellant's opening brief so that they can take a look at what I intend to file. Certificate of service. This is indicating under Rule 5 that I have served both my ex and the Attorney General. Yeah, the Attorney General. This is the lawyer who is, I guess he's the Deputy Attorney General or Senior Deputy Attorney General. And of course, they're representing the Secretary of State. Next document is the notice that no transcripts are requested. This is something that I've talked about before. I think the video is titled Transcript Request Form. If it's not in that video, then it's in filing an appeal. One of those 2 videos talks about what this is. Basically, the court denied my request for costs without a hearing. And so I don't have to ask, for any kind of transcript to a hearing because we never had a hearing. He just denied it on the paperwork. So I'm indicating to the Supreme Court that I'm not going to be requesting a transcript because there is no transcript to request. This is required. You do have to let them know if you don't want a transcript. It's something that they specifically mention in the Rules of Appellate Procedure. They tell you to either file a transcript request form or a notice letting them know that you don't intend to. Here we have a Rule 5 certificate of service indicating that this document is being served upon my ex's attorney and the Secretary of State's attorney. Going into the next document, we have a civil proper person appeal statement. This is a document that I discuss at length in my video filing an appeal. Please take a look at that video if you haven't seen it yet. I don't want to spend a lot of time on explaining the purpose of the proper person appeal statement, or more importantly, what we should just call the case appeal statement. You know what? I hope I'm not mixing this up with the docketing statement. I don't think I am. I think that this is the substitute for the docketing statement that they just give to non-attorneys. If I am wrong, I guess we're going to stumble into the docketing statement later on in the series, but I don't think so. I think this is the substitute for it when you're representing yourself. So if you guys do go and watch the video filing an appeal, it's probably referred to in that video as the docketing statement. In any event, let's go ahead and take a look. So yeah, this contains the instructions on how to file your appeal, how to fill out this form. And okay, so the details that this thing is asking for are very consistent with what you end up filling out in the docketing statement. So this makes me think that I was right. Yeah, because you're mentioning the judgment and order you're appealing, the date that it was filed, when the notice of appeal was filed, the related cases, the issues that are on appeal, the statement of facts. This is all like, it's almost like a combination of the docketing statement and the opening brief. It's like they've blobbed these two documents together into a very short and sweet document for a non-attorney to fill out. Okay, and then we've got the certificate of service indicating that this document has been mailed to both the government's lawyer and my ex. Order directing transmission of the record. So the Supreme Court has reviewed the documents on file in this proper person appeal, and they have concluded that their review of the complete record is warranted. Pursuant to the rules of appellate procedure, they are directing the clerk of the district court to, within 30 days, transmit to the clerk of the Supreme Court the entire trial court record in the lower court case. This is good. This means I passed screening. This is an opportunity for them to just throw my case out, but they reviewed everything that I had filed and they determined that they needed to take a closer look and that they are not going to throw the case out, which is good. Next document, order granting motion. So they have indicated that they have reviewed my motion to file an opening brief under Rule 46 subsection B, and they have determined that briefing of the appeal may aid in its resolution. They are granting me the permission to file an opening brief. The clerk of the court shall file the opening brief that I attached provisionally to that motion that I had requested permission. And yeah, take a look at this. This is what I talked about earlier on in the series. They are ordering that my ex shall not file an answering brief unless they are directed to do so. This is what I was talking about earlier in the series when I filed the notice of appeal. I was mentioning how judges really stick their neck out when they deny an unopposed motion. They talk about this more in the next appeal or the appeal after that, and they explain their reasoning as to why my ex is not allowed to file an answering brief. But mainly the gist of it is the court never took into consideration any of our arguments in lower court anyway. And so she hasn't preserved any arguments for her to assert now on appeal. There's nothing preserved because there was no input from her in the first place at all. So this is going to be an appeal where the court is going to just consider my side of the story only because the lower court, for whatever reason, without even taking into consideration my ex's response, decided to deny my motion. Going into the aftermath, I filed 1, 2, 3. It looks like 3 documents. Those documents were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney on appeal, so I incurred $0 in attorney fees. My ex's attorney would have probably very briefly reviewed these documents. The motion seeking leave of the court, why is she going to care? That doesn't impact her at all. I'm just asking permission to file a specific type of document. The notice that I filed, same issue. All I'm saying is I don't want a transcript. Who cares? Civil proper person appeal statement, she may have briefly looked over. She may have spent more time reviewing the order of the Supreme Court. And that order is actually telling her to not do anything anyway. That's not even something that she's going to have to do any work on. So I think all 5 of these documents, under the circumstances, I think 15 minutes is fair because none of this requires her to do any work. So I think she would have just very briefly glazed over it, put it into her system, and moved on. 15 minutes at the rate of $250 in attorney fees is going to come to $62.50 in attorney fees for my ex. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.